everyone. Moving right into Unit 6. You're doing great. I know the course is long and difficult, but so proud of everyone to continue to go forward. So, today we're talking about the law of agency. And our learning objectives, you should be able to define agency relationship and the parties to an agency, right? So, the realtor, the seller, the buyer. Distinguish between an employee and an independent contractor, right? So a 1099 independent contractor versus a W-2 employee. Describe a single agency and dual agency. Identify the ways in which the agency relationship can be created. List the type of listing agreements and describe them. Describe the contents of a typical residential listing agreement. List the rights and duties of the principal and agent. Explain the contents of the real estate transfer disclosure statement and the agent's statement disclosure. These are very, very important. Very important, these disclosures. Recognize the ways in which the agency relationship may be terminated. All right, let's move right on.
Here is the list of your key terms. Concept of agency. In the traditional view of agency law, a real estate agent most often represented the seller. This was true even when it was the buyer who first contacted the real estate agent. The buyer could be shown dozens of homes and helped through a complicated real estate purchase contract. The agent could even assist the buyer through the escrow process. Despite all that, the real estate agent was first and foremost the agent of the seller. Most buyers never realized that their agent was the seller's agent. It probably never occurred to the agent that the buyer should know. The traditional view of agency law in California has changed. Recent studies, public opinion, court decisions, legislation, and the redefinition of the marketplace thanks to the internet have brought the role of the real estate agent into sharper focus. As the agency relationship is more clearly defined, it becomes easier for all agents to recognize and meet the challenges of that relationship. The real estate agent can better serve both buyers and sellers when all parties concerned know exactly whom the agent represents. Throughout this chapter, we refer to the real estate agent. In every case, the agent is the licensed real estate broker working on behalf of a client, even when the broker is represented by a real estate licensee acting under the authority of the broker by virtue of their employment agreement. The distinction is important because it establishes the duties and expectations of the real estate agent and the expectations and duties of the client. The California Civil Code provides most of the laws dealing with the formation of an agency relationship. The definitions that follow and most of the information in this unit can be found there. To read a specific section of the law, go to www.leginfo.legislature.ca.gov. As you read through this unit, remember that the law, no matter how well established by statute or precedent, is always subject to change. An agent represents a principal in dealing with a third person. The act of representing someone else is called an agency. California Civil Code Section 2079.13a defines the agent in a real estate transaction as the broker under whose license a listing is executed or an offer to purchase is obtained. It is important to remember that all of a real estate brokerage's associate licensees, real estate salespersons, or brokers who work under the supervision of the company's designated broker, including those who work in branch offices, are considered one agent for the purpose of agency duties and liabilities. In the practice of real estate, there are other possible agency relationships. The listing broker acts as the agent of the seller, but the salesperson employed by the listing broker is the agent of that broker. There may be a different broker acting as an agent of the buyer, and that broker may employ a salesperson who acts as that broker's agent, who may take part in an agency relationship. In every agency relationship, there is always a principal, an agent, and a third person with whom the agent conducts business on behalf of the principal. The principal can be anyone who has the ability to enter into a contract. For example, a person who is mentally incompetent or a minor someone under the age of 18 cannot enter into a valid agency relationship. In California, as in all states, a real estate broker or salesperson must obtain the appropriate license. All California real estate licensees must be at least 18 years old and have fulfilled the education and other requirements. Special agent versus general agent. A special agent is one appointed to carry out a single act or transaction. Any other agent is called a general agent. The difference between a special agent and a general agent lies in the scope of authority the agent possesses. Typically, a general agent can enter into an agreement that will bind the principal to its terms, while the authority of a special agent will be subject to the approval of the principal. Example: Broker B is engaged by the G family to sell their home. Broker B is a special agent for that purpose. When Broker B sells the G family's home, Broker B's agency relationship with the G family will terminate. The G family performers who are planning a move from Los Angeles to Las Vegas employ a manager and give that person full authority to carry out their business affairs. What kind of agent is that person? That person is a general agent because of the broad authority given to the agent by the G family. Delegating authority. Some of an agent's authority may be delegated to someone else. The agent may do so without express authority of the principal when the responsibility being delegated involves a clerical or administrative act. Other activities will require the principal's agreement before they can be delegated. Broker M employs an administrative assistant who performs secretarial duties, including typing sales brochures. Broker M's assistant performs none of the tasks that require a real estate license, such as soliciting property sellers and buyers. Broker M does not need the approval of clients to employ the assistant. A complete discussion of real estate listing agreements appears later in this unit. The typical listing contract allows the listing broker to make use of the efforts of the listing broker's staff, as well as the services of cooperating brokers. Cooperating brokers are agents who try to sell a property that is currently listed for sale by a broker, but who work for someone other than the listing broker. Historically, it was taken for granted that the agency relationship was between the listing broker and the seller. Any agent who wrote an offer on behalf of a buyer was considered a subagent of the seller's broker, and with the seller's consent, the listing broker agreed to share the commission with the subagent. Unless subagency was rejected, the cooperating broker was automatically the subagent of the seller and owed all of the duties of a fiduciary to the seller. Delegating authority. Under the practice of subagency, the buyer was not represented by the cooperating broker, but instead was assisted by the cooperating broker. The problem? Almost 70% of buyers believed the agent working with them was working with them. In reality, the buyer was the third party in an agency relationship, and all of the agents were loyal to the seller. California legislation has changed this relationship. The cooperating broker is no longer automatically the subagent of the seller, even though the cooperating broker may be entitled to a share of the commission that the listing agent receives from the seller. The cooperating broker's share of the commission is called the cooperating split or commission to the selling office. Now, a cooperating broker may be the agent of the listing broker, the subagent of the seller with the seller's authorization, typically through use of the multiple listing service or the agent of the buyer. New laws. It is important to remember that the seller's authorization does not necessarily require a written agreement. As you will learn later in this unit, in the section entitled How an Agency Relationship is Created, the conduct of the seller, the principal, also can authorize an agency relationship. Multiple Listing Service. A multiple listing service MLS is an organization of real estate agents that receives information from individual members on their property listings and makes that information available to participating members. MLS members agree to abide by the rules of the MLS. The MLS benefits sellers by making more agents aware of the availability of their property. Buyers benefit from a wide choice of properties from which an agent can present those that meet the buyer's needs. When a real estate broker enters into a listing agreement with a property owner, the owner may authorize the agent to place the listing in the MLS. Information placed in the MLS informs other agents of the asking price, provides a property description, indicates how the property may be shown, and tells the agent representing a buyer, the cooperating broker, what the commission to the selling agent will be. The cooperating broker is entitled to the compensation offered in the MLS, regardless of agency relationships. The MLS listing will also inform other agents if subagency is optional or mandatory. A pocket listing is one that the listing agent markets privately, whether or not it is entered in the MLS. Broker M is the exclusive agent for the O'Connors, who are selling a 4-unit apartment building. The MLS has not been authorized and is not being used, although the property is being advertised for sale. If a cooperating broker brings in a buyer, what is the relationship of that broker to the O'Connors and Broker M? In this case, a cooperating broker would be the subagent of Broker M and have no direct relationship with the O'Connors. Employment relationship of principal and agent. An agency agreement is a form of employment contract. It can be structured in several ways. The principal is the employer, but the agent may act as either an employee or an independent contractor. The main difference is in the type of control the principal exercises over the agent. Another difference is the form of compensation paid to the agent. Real estate sales associates don't have a typical 9 to 5 job with evenings and weekends off. An employee typically is under very close control as to the place where work is performed, the hours spent on the work, and the manner in which the work is carried out. An employee receives wages from which payroll taxes are deducted and may receive other employee benefits. Employee status also subjects the employer to certain liability for acts performed in the course of employment, which will be discussed later. An independent contractor, on the other hand, usually has great flexibility in accomplishing the task undertaken and will receive a commission based on completed transactions instead of a salary with no payroll deductions. Real estate agents generally act as independent contractors in their dealings with clients as well as in their dealings with each other. Don't forget, a real estate salesperson can conduct business only as the agent of a broker, and they must have a written employment agreement. The real estate license law always considers a salesperson to be an employee acting under the direct supervision and control of the broker. This is true even when the salesperson is treated by the broker as an independent contractor for compensation, work assignment, and tax purposes. Single versus dual agency. In a single agency, an agent represents only one principal. Each principal in a transaction is represented by a different broker. In a dual agency, the same agent represents two principals in the same transaction. A dual agency thus places the agent in the precarious position of carrying out agency responsibilities to two principals whose interests are in opposition. This can occur when a listing broker finds a buyer for the listed property. A dual agency can also occur when two associate licensees in the same brokerage work on behalf of the employing broker to represent both buyer and seller. A dual agency places the agent in the precarious position of carrying out agency responsibilities to two principals whose interests are in opposition. Any agent who acts solely or through employees of the brokerage on behalf of both parties to a transaction is required by law to inform both parties and obtain their written consent to the dual representation. The law is very specific with regard to the activities of real estate agents. A real estate broker in a dual agency relationship must make sure that both clients know of and consent to the dual representation in writing and in advance of any representation. Otherwise, the agent faces temporary suspension or even permanent revocation of the real estate license, in addition to having to return any commission received on the transaction. The penalty may seem severe, but the chance or even the appearance of taking advantage of the special knowledge an agent possesses makes a dual agency a difficult enterprise. Not only does the broker have a real estate license to consider, a party acting without knowledge of the dual agency also could ask the court to rescind any contract that results. Agency disclosure form. From January 1st, 1988 through 2018, the details of the agency relationship were required to be disclosed in any transaction involving property of 1 to 4 residential units. As of January 1st, 2019, disclosure of the agency relationship has been expanded to include multifamily residential property, mobile or manufactured homes, commercial property, and vacant land. A written document that explains the various relationships of those involved in the transaction and exactly whom the agent is representing must be presented to both buyer and seller as soon as possible. The written disclosure must be made by the seller's agent to the seller before the seller signs the listing agreement, the buyer's agent, who may also be the seller's agent, to the buyer before the buyer makes an offer to purchase, and the buyer's agent, if different from the seller's agent, to the seller before an offer to purchase is accepted. The wording of the form must follow the wording specified in the Civil Code. In addition, the code sections dealing with the disclosure requirements must be printed on the back of the form. The buyer's agent's relationship must be confirmed in writing in the purchase contract, or a separate writing executed or acknowledged by the seller, the buyer, and the buyer's agent before or at the same time the purchase contract is executed by buyer and seller. The seller's agent's relationship must be confirmed in writing in the purchase contract. A separate writing executed or acknowledged by the seller and the seller's agent before or at the same time the purchase contract is executed by the seller. Power of attorney. An attorney at law is someone licensed by the state to practice law. An attorney, in fact, is an agent who has been granted a power of attorney by a principal. A power of attorney authorizes an agent to act in the capacity of the principal. An attorney takes someone else's place. A special power of attorney gives an agent authority to carry out a specific act or acts. A general power of attorney authorizes an agent to carry out all of the business dealings of the principal. Example: the following case problems illustrate some of the concepts you have just learned. Identify those concepts and answer the questions asked about them. K has been declared mentally incompetent and resides in a nursing home. K's parents, who have moved to Retirement City, transferred title to their ranch to a trust established for K, their only heir. K learns of this and contacts a leading salesperson for XYZ Realty about selling the ranch. The salesperson knows the property will sell quickly. Should the salesperson's firm take the listing? All of the salespeople at C Real Estate work strictly on commission. No deductions are made from their commissions, which they share with C. They have no office duties and are billed for any use of secretarial staff, phones, conference rooms, and so on. They do receive referrals from C, which they can accept or reject. Describe the relationship between the broker at C Real Estate and the firm's salespeople. Salesperson P is a good friend of D, who asks P to find a small office building for D's mail order business. D offers to pay P $1,000 as a fee if P can find a suitable building available for occupancy within 30 days. D and P sign a written agency agreement to that effect. The next day, P is approached by N, who wishes to sell an office building that meets D's specifications exactly. Can P initiate an agency agreement on behalf of P's broker with N? In other words, can P list N's property for sale? If P lists N's property, can P then show that property to D? Should P do that? How an agency relationship is created. The agreement between principal and agent that forms the basis of the agency may come about in one of several ways. This section discusses the creation of an agency relationship by express agreement, ratification, and estoppel. Express agreement. An express agreement is established by an act of the parties that both parties acknowledge. The agreement does not have to be in writing unless the law requires a writing, or the agent is to perform an act on behalf of the principal that requires a writing. This is known as the equal dignities rule. An agency permitting an agent to establish such a contract for the principal must itself be in writing. The statute of frauds stipulates the kinds of contracts that must be written to be enforceable. 3 rules applicable to real estate are summarized as follows. The California real estate law requires that the employment agreement between a real estate broker and salesperson be in writing. The statute of frauds dictates that a contract for the sale of real estate or the lease of real estate for longer than 1 year must be in writing. This means that any agency agreement authorizing those actions must be written. The statute of frauds also requires that a contract that authorizes an agent to find a purchaser or lessee for more than 1 year of real estate a listing agreement be written. Ratification. An agency could also be established by a subsequent ratification authorization by either the principal or the agent of an activity of the other that held out an agency relationship. Example: a broker knows that a neighbor is trying to sell a small lot downtown that is zoned for commercial use. Because of its size, the lot is worth about $5,000. The broker offers to find a buyer for a 10% commission. The property owner does not make a commitment but offers to think it over the next day at a Chamber of Commerce luncheon. A member mentions to the broker that a friend needs a small lot downtown to open a sandwich shop. The broker mentions the neighbor's property and receives an enthusiastic response. Later that day, the broker meets the friend at the downtown lot and is told that they are willing to offer $4,500 for it. The broker brings the offer to the neighbor. If the neighbor accepts the offer, will the neighbor have to pay the broker a commission? If the property owner accepts the offer, that action will ratify an agency agreement with the broker on the terms discussed earlier. Caution: if an agency agreement for the sale of real estate is formed by ratification, the ratification must be in writing and comply with all of the other formalities that would ordinarily be required for a valid real estate contract. Estoppel. Another way to form an agency by operation of law is by estoppel. Someone may represent that another person is her agent, and a third person may rely on that representation and deal with the agent accordingly. If so, the principal will not be able to evade the agency relationship. An agency created by estoppel is also called an ostensible agency or implied. S tells J that B is selling the S home. S hasn't signed a listing agreement with B yet. J brings an offer to B, who prepares a written offer to purchase, listing B as the broker and stipulating a commission rate. S can accept the offer by signing it. If S does so, will an agency be created? Yes, if S accepts the offer, which lists B as the selling agent entitled to the sales commission. S's acceptance by signing the agreement would satisfy the requirement for a writing. Agency agreements. An agreement creating an agency is a form of contract. This section begins with a discussion of general contract requirements. Then, the types of listing agreement are explained. Finally, examples of a listing agreement and a buyer brokerage agreement are discussed. Requirements for a valid contract. A real estate agency agreement must comply with the following legal requirements to create a valid contract. The agency agreement must be made by parties who have the capacity to contract. Both parties must consent to the terms of the contract. The contract must have a lawful objective. There must be consideration, that is, an obligation on both parties. A real estate listing agreement generally requires the broker the agent to find a buyer. If a buyer is found, the seller the principal will be required to pay the agent a commission based on the sales price agreed on by the seller and buyer. If all of the above requirements are met, a bilateral contract has been formed. Each party to the contract has a separate obligation to perform, as provided in the contract. When only one party has an obligation under the contract, a unilateral contract is formed. A seller of real estate, for example, must pay a commission if the broker finds a ready, willing, and able buyer. But if a listing agreement is a unilateral contract, the broker is not obligated to exert any effort to find such a buyer. Due diligence implies a good faith effort to fulfill contract obligations. For obvious reasons, unilateral contracts to sell real estate are not common in California. Listing agreements as well as other agency agreements such as the broker-salesperson contract discussed in this unit require the agent to use due diligence in carrying out the purpose of the contract. The role of the agent is defined in the agency agreement. For example, salesperson S signs a broker-salesperson contract with broker B. S is to use due diligence in handling the listings of B's company. In return, S will receive a percentage of the commission on every transaction S assists in completing. What is B's obligation under the contract? What is B's obligation if S fails to sell, lease, or rent any listings? B will pay S a share of the commission received on a completed transaction. B has no obligation to pay S unless S brings about a sale or other transaction. The real estate agent's commission. In California, real estate commissions are negotiable. There is no predetermined commission rate. Seller and broker are free to set whatever rate they agree on. Authority of an agent. The actual authority of an agent is what is specified in the agency agreement. An agent can be given authority to do any lawful thing short of a personal act that only the principal can perform. A real estate agent, for example, can be authorized to conduct an open house but will not be able to order repair work done on the property. An agent's authority may be broadened in an emergency, if immediate action is required and the principal is unavailable. A typical real estate listing agreement specifies the obligation of the broker in soliciting offers for the property specified. Under a broker-salesperson contract, a salesperson is employed by a broker for compensation or in expectation of compensation to perform an act the broker could perform. An agent also has inherent authority, depending on the nature of the agent's obligations. There always are activities the agent needs to perform that are not mentioned in the contract, no matter how detailed. In conducting an open house, for instance, a real estate licensee may advertise, distribute flyers in the neighborhood, and post signs at nearby intersections, none of which is likely to be specified in the listing agreement. An agent may appear to have authority he does not have. This apparent authority places no obligation on the party the agent claims to represent, but it will make the agent liable for his representations. Handling deposits. One of a real estate brokerage's most important obligations, as expressed in standard listing agreement forms, is to receive a deposit from a prospective buyer. The form of the deposit must be clearly disclosed to the seller and may influence the seller's decision to accept or reject the offer. For example, the offer may be accompanied by a demand note paid a buyer note or post-dated check. either of which will be less desirable than an immediately negotiable check. Within 3 business days following receipt of deposit funds by the broker or broker's salesperson, if the funds have not been returned to their owner. They must be placed in a neutral escrow depository or in a trust fund account set up for the specific purpose of handling client and customer monies. A deposit check may be held uncashed by the broker until acceptance of the offer if the check is not negotiable by the broker, or the offeror has given written instructions that the check may not be deposited or cashed until acceptance of the offer, and the offeree is informed that the check is being held uncashed. In most cases, the deposit is placed in an escrow account if the contract offer is accepted by the seller. If the offer is not accepted, the deposit is returned to the buyer. In either situation, the agent should make a record of the check's disposition. Unless specifically authorized by the seller in a listing or other agreement, a real estate broker or sales associate acting for a broker taking possession of a buyer's deposit is acting as the buyer's agent. A buyer's representative who agrees to transmit the buyer's deposit to a seller should make sure the deposit is made out correctly and held in a safe place until it is delivered. Above all, the real estate agent must avoid commingling funds. This occurs if the agent, whether broker or broker's sales associate, places client or customer funds in the agent's personal account. The real estate commissioner can bring disciplinary action for any violation of this rule. The easiest way to avoid problems is to have the deposit check made out to the escrow closing agent. Worse than the commingling of funds is the conversion theft of funds that are not the property of the real estate agent. Even if this happens inadvertently, such as when funds are withdrawn from an account that has mistakenly commingled a client's or customer's funds with those of the real estate agent, disciplinary action and/or a criminal complaint will be the result. Exercise. C. A licensed real estate broker lists a house for sale. If C becomes ill and is unable to carry out the terms of the agreement, can C delegate that responsibility to another broker? Broker C has received an offer on the listed house along with a deposit check for $1,000, which C's agency agreement authorizes C to receive. It is early evening when C receives the check, and the offer will be presented to the seller the next morning. What should C do with the check in the meantime? Broker C has been given a deposit check for $2,000 by a buyer. C neglected to tell the buyer to whom to make out the check, and the buyer made the check out to C. The buyer's offer is accepted. C deposits the check in a personal account and immediately writes a check on that account to the title company that will handle the escrow for the sale. Has C acted correctly? Listing agreements. The 2 parties to a listing agreement are the seller and the seller's broker. An agreement establishing an agency relationship between a real estate property owner and a real estate broker for the purpose of selling real estate must be in writing. A written agreement should be signed by both parties as soon as possible after the client has indicated a willingness to list property. The following box summarizes all forms of written real estate listing agreements. Note that all refer only to the real estate broker, because a salesperson associate licensee can act only on behalf of a broker. Open listing. Non-exclusive. Commission earned only if listing broker is procuring cause of sale. Exclusive agency listing reserved seller listing. No other broker authorized. Owner may sell without owing commission. Exclusive authorization and right to sell listing. No other broker authorized. Cooperating broker may be brought in. Commission owed no matter who sells the property. Net listing. No other broker authorized. Seller receives predetermined amount and broker receives excess. Option listing. No other broker authorized. Broker has right to purchase the property. Requires full disclosure to seller of broker's profit if option exercised. There must be a definite termination date in any agreement that makes the listing broker the exclusive agent of the seller. The Business and Professions Code provides for suspension or revocation of a real estate license if the licensee claims, demands, or receives any compensation under any exclusive agreement, if the agreement does not contain a definite, specified date of final and complete termination. Open listing. An open listing, also called a non-exclusive listing, provides for a commission to the broker if the broker is the procuring cause of a sale. It provides no compensation if another broker fulfills that task or if the owner does. To be the procuring cause of a sale, the agent must be the one who brings the parties together, or at least must initiate the contact that leads to a sale. Because there is no assurance that the listing broker will be the one to sell the listed property, this form of listing generally is avoided in residential transactions. It is often used in industrial and commercial property transactions, however. With an exclusive agency listing, which may also be referred to as a reserved seller listing, the property owner cannot list the property with another broker at the same time. The listing broker thus has the protection of getting at least a share of the commission if another broker finds a buyer. The protection is not complete, however, because the owner still may find a buyer without the broker's assistance and thus avoid paying any commission. In effect, the listing may become a sale by owner, exclusive authorization and right to sell listing. The most commonly used form of agreement, and the only one that will be accepted by most brokers, is the exclusive authorization and right to sell listing. With this type of listing, the broker is entitled to a commission no matter who sells the property, even if the owner appears to find a buyer without the broker's assistance. The buyer may have found the property address on the internet, for example, or may have seen a sign on the property and contacted the owner directly. The listing broker is the owner's agent but may have the option of being a dual agent. The commission typically is shared with any cooperating broker or subagent who procures a buyer. This type of listing agreement usually contains a safety clause or broker protection clause that will cover a buyer the broker is working with even after the listing expires, as long as the broker has registered that buyer with the owner before the listing expiration. The contract will specify the length of time after the listing expires during which the broker may still be compensated, whether or not the owner signs a new listing agreement with a different broker. The multiple listing clause that is a part of the exclusive authorization and right to sell listing allows the property to be made available to other brokers participating in the MLS. The requirements of the broker's MLS determine whether the broker must place every listing into the MLS and how members of the MLS will be treated. Example: L lists a residence for sale. Broker R has an MLS clause in the exclusive authorization and right to sell listing agreement with L. If broker B, a member of the MLS, finds a buyer, does R deserve a commission? Yes. R is entitled to the listing broker's share of the commission. Net listing. In a net listing, the broker's compensation is whatever amount the property sells for over a previously agreed net amount. If the selling price is equal to or less than the agreed on net listing amount, the broker receives no compensation. Before it is accepted by the seller, this kind of agreement requires full disclosure of the selling price and the amount of compensation the broker will receive. Without these disclosures, the broker and any associate licensee who has initiated the listing may face license revocation or suspension. Because such an arrangement is both inherently risky, the broker may earn little or no compensation, and inherently suspect a high commission may hint at a too low net listing price. It should be avoided. Option listing. An option listing gives the broker the right to purchase the property. The broker thus can possibly be both a principal and agent in the same transaction. The broker must be scrupulous in fulfilling all obligations to the principal, particularly in informing the principal of all offers. If the broker exercises the option, the principal must be informed of the broker's profit in the transaction and agree to it in writing. An option listing is legal in California, but strongly discouraged. Terms of the listing. The features of the contract are explained in the following list. Following the date on which the contract was prepared, space is provided for the seller's name, the broker's name, the dates the listing will begin and end, the city and county in which the property is located, the assessor's parcel number, and a detailed enough description to exclude all other property. Listing price is indicated in words and numbers. The seller's preferred purchase terms also can be indicated. The commission rate on the sale of a single-family residence is negotiable. This fact is required by law to appear in the listing agreement for property of one of 4 residential units, the broker's safety clause. The parties agree to a reasonable time after the expiration of the listing agreement during which the seller will be obliged to broker or a cooperating broker during the listing term buys the property. The broker should give the names of such prospective buyers to the seller within 3 calendar days of termination of the contract. The contract should stipulate any fixtures the owner is excluding or personal property such as furniture the owner IC including in the sale. any items on the property that are leased or that have caused a lien to be placed on the property because they have not been fully paid for, such as a water softener, solar power system, or alarm system. The Multiple Listing Service MLS is defined. The broker is authorized to use the MLS unless the seller gives written authorization to exclude the listing from the MLS in a separate form. The seller can exclude the property from display on internet sites or electronic displays of MLS participants and subscribers, but that exclusion may not limit access to property information made available by other internet sites that are not under the control of the MLS. The benefits of using the MLS and the impact of the seller opting out of using the MLS are emphasized. Elements of the marketing of the seller's property are explained. Use of the internet to market the seller's property and the seller's choice of limitations on the information publicized on the internet are detailed. The seller knows of no loan delinquency, bankruptcy, or other legal action that would affect the property or its transfer. The broker promises to use reasonable effort and act with due diligence to find a buyer for the listed property. The broker is authorized to advertise and market the property. The seller promises to consider all offers presented by the broker and to act in good faith. The seller agrees to indemnify the broker, including paying the broker's legal fees in the event of a dispute stemming from any incorrect information supplied by the seller. The broker is authorized to accept a buyer's deposit for the seller. The seller acknowledges receipt of an agency disclosure form. The broker will act as agent of the seller. Any other agency relationship requires agreement of seller and broker. Seller also acknowledges receipt of a dual agency disclosure form. The agreement will terminate as provided in the agreement or on completion of any transaction specified in the agreement. It is the seller's responsibility to insure and protect household belongings while the property is listed for sale. The seller should post a notice of any security cameras on the premises. The seller may or may not give the broker permission to use electronic images of the property, but the seller acknowledges that the broker cannot control the taking of property photographs by prospective buyers or other persons. The seller may or may not allow the use of a lockbox attached outside the house with the house key inside, accessible to brokers. The seller may or may not allow a for sale or sold sign on the property. An anti-discrimination clause is evidence of the party's intent to obey all applicable laws. Both broker and seller are made aware that if a legal action ensues, each party is responsible for paying their own attorney's fees and costs. The listing agreement may be subject to lender requirements if the property is lender-owned REO or is being sold for less than the remaining loan balance short sale. Any other items not already covered can be mentioned here, such as repairs to be made by the seller. This is also the place to mention any potential buyers the seller has already contacted with whom the seller wishes to deal without paying the broker a commission. If an associate licensee signs the contract on behalf of the broker or the broker's manager has a 5-day right of cancellation. The contract can be assigned. The broker and seller agree to submit any differences of opinion to mediation before going through a formal arbitration process or beginning legal action in court subject to the exceptions noted in this clause. The broker and seller may agree to submit their differences, if any, to binding arbitration except as the clause specifies. Note in 2005, the California Supreme Court held in Grafton Partners v. Superior Court that any pre-dispute contractual waiver of the right to a jury trial is constitutionally invalid. The agreement incorporates any prior understanding of the broker and seller, whether written or oral. The seller must warrant to being the owner of the property and that there are no exceptions to that ownership interest. A legally authorized signer may execute this and related documents on the seller's behalf. The date of signing is given, and the seller signs. If an owner is married, even if the real estate is the seller's separate property, the other spouse's signature should also be obtained, either directly or through a power of attorney. The correct address of the sellers and other contact information are also important. The broker signs and dates the contract. The firm's mailing address and other contact information is provided. An associate licensee or licensees can sign on behalf of the broker on the next line. A separate signature addendum can be attached if two brokers with different companies are co-listing the seller's property. In completing a listing agreement, the real estate agent will be guiding the property owner through a legally binding contract, yet the agent is not permitted to give legal advice. If the owner is confused about the meaning or ramifications of any of the contract terms, the agent should recommend in writing that the owner consult an attorney before signing. Statewide buyer and seller advisory. In recognition of the buyer's and seller's responsibilities to each other, as well as federal and state obligations, CAR has prepared a 14-page form that lists the areas of responsibility that can occur in a transaction. The buyer and seller advisory includes information on disclosures, the possibility of required repairs, tax withholding, lead-based paint, geologic and fire hazards, and other safety and transaction concerns. The form is to be signed by both parties as well as both agents. Buyer-broker agreements. The real estate broker does not always represent the property seller. Increasingly, property buyers are recognizing the important advantages that can be obtained by having their own broker represent them in a transaction. As with other real estate contracts, the terms under which the buyer's broker will function must be specified in writing. Note the following contract clauses. Clause 1 specifies the type of property the buyer is seeking. Clause 2C1 states the limitations on the broker in a possible dual agency representation. Clause 2D provides for the buyer's acceptance of the broker's representation of other buyers seeking the same or similar properties. Clause 3 stipulates the type of compensation to be paid to the broker. This could be a fee to be paid to the broker based on a stated amount or percentage of the purchase price of the property. Provision is made for compensating the broker in the event that the buyer enters into an agreement to purchase property that the broker introduced to the buyer, so long as the agreement is entered into within the specified number of days of the expiration of the representation period. The terms under which compensation is to be paid are stated, as is the fact that any compensation that the buyer's broker collects from anyone other than the buyer is to be credited against the fee due from the buyer. Clause 4 explains that the broker has no control over comments or postings on the internet regarding properties that have been shown to the buyer. Buyer representation agreement exclusive. Rights and duties of principal and agent. Both parties to an agency agreement have obligations. An obligation owed by one party is a corresponding right of the other party. The agent has the obligation to use due diligence in fulfilling the purpose of the agency agreement. This obligation also may be expressed as the right of the principal to have the agent use such diligence. This section examines the duties each owes and the consequences of any failure to perform those duties. The real estate agent owes the principal the following duties of a fiduciary: obedience, loyalty, disclosure, confidentiality, accounting, reasonable care and skill. Duties of agent to principal. One of the most important duties the agent owes the principal is the duty of loyalty. The agent in a real estate transaction acts as a fiduciary, a person to whom property or the power to act is entrusted on behalf of someone else. The agent's role in the transaction is to consider the interests of the principal first and foremost. The agent's fulfillment of the duties of good faith and honesty will allow the agent to fairly represent the principal's interests. The agent must respect the confidentiality of personal information made known to the agent by the principal. This duty extends to computerized data compiled or obtained in the course of business. Civil Code Section 1798.29 requires notification to any resident of California in the event of a breach of such data. The notice of data breach must follow the prescribed statutory format. To the extent required by their agreement, the agent owes the principal the duty of obedience in relevant matters. The principal cannot obstruct the agent's activities but can direct the agent generally. For example, a real estate agent cannot insist on showing a seller's property to prospective buyers at any time but must respect the seller's wishes. The seller, on the other hand, should comply with reasonable requests to show the property. The agent must make full disclosure of all material facts concerning the transaction to the principal. The agent makes an accounting to the principal of the details of the transaction. This is a sensitive area for a real estate broker representing the seller in a transaction. A listing agent who brings a buyer to a seller should have qualified the buyer financially and discussed the buyer's purpose in buying real estate. Even if the listing agent legally represents only the seller, the agent inevitably is made aware of information that is useful to the seller. For example, the seller's agent may have learned that the buyer is an out-of-state transferee with only a limited time in which to find a house. In such a case, the seller may have a stronger bargaining position. By law, the agent must disclose such information to the client, the seller. Most real estate licensees walk a fine line in balancing their obligations to their principal against their desire to gain the confidence of the person they want to bring to a successful transaction. The agent also must disclose to the principal any possible conflict of interest, such as dual representation. The agent must disclose to the principal any relationship the agent has to another party to the transaction, even if the agent or other party will derive no benefit from the relationship. At times, even the appearance of impropriety is sufficient to require the agent to act. Of course, the agent can make no secret profit in a transaction. Example: XYZ Realty has listed a house for sale. A sister of the broker who owns XYZ Realty wants to make an offer on the house. Can XYZs take the offer to the property owners? Yes, but the relationship of the offerer to the broker must be disclosed to the sellers first, regardless of the terms of the offer. The agent owes the principal the duty of reasonable care and skill in carrying out the tasks dictated by the agency agreement. This is true even if the relationship is a gratuitous one in which the agent receives no compensation. After the agent has performed services on behalf of the principal, whether or not for compensation, the agent owes the principal the duties of a fiduciary. Duties of subagent to principal and agent. A subagent owes to the principal the same duties as the agent and also owes those duties to the agent. The agent bears the responsibility of taking reasonable steps to ensure that the subagent acts with the required loyalty and care. Otherwise, the agent may be liable for any improper act or failure to act of the subagent. If the subagency was authorized by the principal shares that liability. If the agent's contract obligations have been fulfilled, the agent is entitled to the agreed-on compensation. The agent must be the procuring cause of the sale, lease, rental, or other transaction. In other words, the agent must be the person who initiated the contact that brought the third party to the principal. In a listing for sale, the seller usually agrees to pay the broker a commission that is a percentage of the actual sales price. In a lease or rental agreement, the agent's compensation may be a percentage of the lease or rental value or a flat fee. When is a commission earned? In a real estate listing agreement, the commission is earned when the real estate broker finds a buyer who is ready, willing, and able to purchase the subject property on the seller's original terms, or when the seller accepts a purchase offer at an agreed-on price, terms, or both. The principal can revoke the agency agreement but is liable for the expenses the agent has incurred and may be liable for the full amount of the agent's commission. In an open listing, if the seller accepts an offer that was not secured by the listing broker, the seller need not compensate the listing broker. If more than one acceptable buyer is brought to the seller, the listing broker will receive a commission only if his buyer is the first in time. Example: XYZ Realty has an open listing agreement with K. XYZ brings K a buyer who will pay the asking price and is otherwise qualified financially. While K is considering the offer, a good friend offers to buy the property for $3,000 less than the asking price. To avoid paying a sales commission, K accepts the offer. Does K owe the XYZ broker a commission? Yes, because the first acceptable offer came through XYZ's Realty. If the offer through XYZ's was not at the seller's original terms, the seller would be free to accept the friend's offer without obligation to pay a sales commission because XYZ's and K had an open listing agreement. With the protection offered by an exclusive authorization and right to sell listing agreement, the listing broker will receive a commission regardless of who produces the buyer. A rare exception to this general rule may occur if the seller identifies a prospective buyer in the listing agreement as someone to whom the property may be sold without payment of compensation to the broker, and that person buys the property. Duties to third persons. A real estate agent owes to a third person a duty of full disclosure of material facts that the agent knows or should have known regarding the property that is the subject matter of their dealings. The agent bears this responsibility independent of any instruction received from the property owner. If the property owner tells the agent not to reveal certain defects, such as termite damage, the agent must inform the principal that the agent cannot hide such information. To do otherwise would make the agent liable for money damages and place the agent's license in jeopardy. Material facts. A material fact can be anything that would affect the value or desirability of the subject property. Because this is such a broad definition, the legislature and courts have created their own interpretations of just what the prospective purchaser needs to know. Conspicuous physical defects must be revealed, certainly, but other factors may not be as easy to understand. It is not necessary, for instance, to reveal a death on the premises that occurred more than 3 years before an offer to purchase or lease is made. Nevertheless, the agent handling such a property may not make a misrepresentation if asked a direct question by the buyer. But the agent need not reveal that an occupant of the property was afflicted with or died from acquired immunodeficiency syndrome AIDS. This provision appears in Civil Code section 1710.2, Easton versus Strasburger. The decision in the California case of Easton versus Strasburger 1984 expanded the broker's duty of disclosure to third persons. The court held that a real estate broker has an affirmative duty to conduct a reasonably competent and diligent inspection of residential property and to disclose to prospective purchasers all facts revealed by the investigation that materially affect the value or desirability of the property. This duty was subsequently recognized by the California legislature and made a part of the Civil Code. Starting at Section 2079, it applies to residential property of 1 to 4 units. The Easton case involved a house built on landfill. That fact, and the fact that one of the broker's agents noticed an uneven floor, should have acted as red flags warranting further investigation and disclosure to the buyer. If there is a substantial property defect the agent could have discovered by a thorough inspection of the property, even if the agent failed to notice the defect, the agent may be liable to a buyer for any resulting damages. Easton renewed interest not only in the broker's duties to prospective purchasers of residential property, but also in the seller's duties to prospective purchasers. The seller must disclose any material fact known to the seller that affects the value or desirability of the property, including defects that could not be discovered from casual observation of the property. In addition, every seller of a residential property of 1 to 4 dwelling units must disclose to a potential buyer whether, during the course of the seller's ownership or through previous knowledge, any structural additions or alterations were made to the property, and whether they were made with or without benefit of an appropriate permit. The seller of residential property of 1 to 4 units must provide the buyer with a written real estate transfer disclosure statement that details the mechanical and structural conditions of the property in a form specified by law. The disclosure requirements are subject to change. Use of a form such as that prepared by the California Association of Realtors is the best way for the seller and broker to be sure that the buyer is fully informed of the property's condition and that all legal requirements are met. Note that the agent's disclosures are limited to a competent visual inspection of the property. Such an inspection should reveal patent defects, those visible to an agent. The agent is not expected to be aware of or investigate latent defects, those not readily apparent. Seller disclosure is also required in a sale of a used manufactured home or mobile home if the home is classified as personal property. Wording of the disclosure form is provided in Civil Code 1102.6d. Termination of an agency. The California Civil Code lists the ways in which an agency relationship may be terminated. They are summarized in the box below. Ways to terminate an agency. Fulfillment of the agency agreement. Expiration of the term of the agreement. Destruction of the property. Death of either the principal or agent. Incapacity of the agent to act as an agent or incapacity of the principal to enter into a contract. Agreement of the principal and agent. By operation of law, as in a bankruptcy. The principal or agent always has the power to terminate the agency unilaterally without the other person's consent in writing. But the person who terminates the agency may be liable for damages to the other party. An early cancellation of a listing agreement by a seller is an example of a situation in which the seller may be liable to the listing broker for expenses or a commission. Notice of termination must be given to third parties with whom the principal and agent are dealing.
All right, everyone, good work. You got through that unit. And a small little summary here is talking about the agency relationship establishes the authority of the agent as either a special agent or a general agent to act on behalf of a principal in dealing with third parties, right? Agents representing a client in a real estate transaction must always be a licensed real estate broker. A real estate sales associate can perform real estate activities, but only under the authority of a sales employing broker. The real estate listing agreement authorizes a broker to receive a deposit on behalf of the seller, market the property, and authorize payments to cooperating brokers. The Multiple Listing Service, MLS, is an association and a network of agents who place their properties listed for sale in this network. All right, we'll see you in the next chapter. Bye bye.